believe you. But I've really made my point. And like I said earlier on, there was really no basis for whatever happened yesterday. I believe that the Supreme Court, constituted by those 5 judges led by the Chief Justice, clearly exceeded their powers in suspending a decision of Parliament that they had not declared as being in violation of any provision of the Constitution. The Supreme Court has not said that, the Speaker's interpretation is wrong. The Supreme Court has not said that. The Supreme Court has not said that the Speaker's decision to conclude that when you file to contest as an independent candidate, when you are a sitting member of Parliament on the ticket of a political party, you lose your seat. The Supreme Court has not yet said that that is right or wrong. Are you getting the situation? And yet, they interfered with the proper functioning of Parliament by going to suspend that decision. You haven't said the decision is wrong, and yet you have suspended it. On what basis? On the basis of what authority are you doing that? If we allow you to suspend this one, which other decision will you not suspend? So every day we go and sit, we are not sure whether this decision that we have taken today, the Supreme Court will suspend it. Is that how the democracy is supposed to function? And your power is to declare that we are either wrong or we are right. So if you declare that we are wrong and therefore you are annulling our decision, fine. But to suspend our decision, on what authority are you suspending our decision? If you are in a hurry, you could have just done the interpretation yesterday and given your ruling yesterday. You could have done that yesterday. But for Parliament, we to meet and take a decision, then you will suspend it. How? How can that happen?
What the Supreme Court cannot do in this instance, what you're saying is to second guess the Speaker by determining whether or not his application of the law in terms of the determination of vacancy, whether the Speaker has properly done so or otherwise. So that's the fine line we're saying here.
No. When the Speaker enforces a provision of the Constitution by taking a certain action, that is to say that you are a sitting member of the MPP in this House, and you have gone to file as an independent. By my reading of Article 97 1G and H, you have vacated your seat, so leave this chamber. Is that okay? When the Speaker does that, the Supreme Court can, when somebody goes to them for a declaration, declare that, Mr. Speaker, you are wrong. I get the point. When somebody, is a sitting member of Parliament on a political party ticket, goes to file as an independent, it doesn't amount to vacating the person's seat. So I'm annulling your decision. I'm declaring that your action is null and void. That's the declaration. That is not what happened yesterday. What happened yesterday was the Supreme Court hasn't declared that his decision is wrong. Are you getting the point? But has interfered in his work and suspended his decision. And I'm saying that we're a coordinate arm of government. We're either wrong or we're right. But you have no business interfering in our work. And it is the same Constitution that establishes your office and that says that you are Supreme Court. That also says that when we are working, you shouldn't interfere in our work.
And this is until the determination of the case. So that's indefinite.
Yes, exactly.
Is that regular?
Exactly.
Is it regular to have an ex parte motion run indefinitely until the determination of a particular case?
I am even saying that in this instance, the whole idea of an ex parte motion and etc. is wrong, is flawed. Because you need to act on the basis of the fact that this is a special situation where we are dealing with the architecture of government, where you have the Supreme Court, you have the executive, and you have the legislature. Is that okay? And then you have clear provisions of the Constitution that says, hey, when the legislature is doing its work, I beg you, don't interfere. If you interfere, it amounts to contempt. Clearly stated. Are you getting the point? Clearly stated. I'm saying that under our Constitution, there are only 2 bodies that the Constitution protects from their work being interfered with. Okay? That is the legislature and the executive. The judiciary. And there are 2 bodies that the Constitution gives the power of, punishment for contempt. And they include the judiciary and again the legislature. So that protection that the Supreme Court seeks to give to the legislature is a protection that the Supreme Court must respect. The same way that the Constitution also gives the judiciary some protection that we also respect, such as the clear provision of the Constitution that when there is a matter that we cannot pass a judgment, we cannot pass a law reversing a judgment of the judiciary. Is that not it? Yes. It's in the Constitution. Yes. So it's a protection given so that the judiciary will not take a decision. They will come and sit and say, we don't accept this. Let's pass a law that says that what the courts have done is wrong. We will not abide by it. So these are protections given under the Constitution. And the judiciary must be mindful of those issues. And I'm saying that whole argument that the business of the House will be disrupted, that government cannot do its business, that there will be a crisis in the parliament, it has nothing to do with the Supreme Court. These are political matters. And Baker and Carr is clear that the Supreme Court should not get itself and should not dabble in political issues. Leave the coordinate branches of government that are political in character to deal with their matters politically. Why? If we go to the House and 2 or 3 MPP members of Parliament don't show up, we can still disrupt government business by voting against it. We can disrupt government business by voting against it. Will you come and say, because government business was disrupted, there's a violation of the Constitution? So these are political matters that the Supreme Court should not be bothered, should not get involved in. That's my basic underlying point. That don't allow them to come and frighten you that, and there will be chaos in Parliament. Why chaos? It is the rules of the Constitution that are being interpreted. When, what's his name, Professor Michael Kwe gave the ruling, Afenyo was in the House.
Yeah. Well, now they say it's
Joe Garte was in the House. Listen, Joe Garte was in the House. Is that okay? All those who were making noise, they were in the House.
Politics of convenience.
Is that okay? Yeah. They didn't see that there will be chaos. They didn't see that the business of the House being disrupted. I mean, today, all of a sudden, the same provision, the same set of facts, the same application by a speaker, and then all of a sudden there is chaos, there will be confusion. If that confusion occurs, it is going to occur because of what the Supreme Court has done.
Are we faced with a constitutional crisis?
Why?
No, from Tuesday.
I am saying that don't be in a hurry. Tuesday is coming. When Tuesday comes, we will see what will happen. Don't be in a hurry.
The tail of a lion.
I'm saying that don't be in a hurry. Tuesday is coming. Tuesday we will see.
Mahama Ayariga is MP for Boko Central, and but Dr. Pagre Boache Tankwa, because you are not a lawyer, obviously following the conversation. We are at this point because essentially your party took a decision, is it not? Prior to the 2020 elections, and now you describe that decision that you found comfort in as unlawful. And so you do not recognize the precedents that has been set. And as a result, you would want to challenge the speaker's ruling based on the precedent that was set that favored you. Why are you doing this?
Mr. Okansi, is it possible to make a small intervention?
Brief one. With your permission.
I'm not the host. You are in charge.
Yes. So, as if you were doubting the existence of the secular. You said
I actually have it. Yes. So I have it. We're going to put out the secular.
12 July 2024 under the speaker. Okay.
I'll show it. So
the hand of the Judicial Secretary.
You know, Alfred, it's a very interesting morning of law, interpreting the law, the 1992 Constitution, the rights of Parliament. You know, it reminds me of theologians arguing the Bible and imams arguing the Quran. Because, you see, whichever way you take it, right, one has to be able to make a case that is constructive enough to the spirit of the letter. At the start of all of these debates about the NDC wanting to become the new majority and moving the democratically elected majority of the New Patriotic Party into a purported minority was very absurd for me. Very, very absurd, just to start with. And I'm clear in my mind that the suspension that the Supreme Court has placed on the reasoning of the ruling that the Speaker gave would bring a lot more clarity, because where you find misinterpretation, lack of clarity, you need to pause and allow a broader conversation. There are a few cases in reference that I would quote here. You know, Ampofwe versus the Attorney General stated very clearly that the Supreme Court has concurrent jurisdiction in the enforcement of the fundamental human rights when it does not affect the person applying to the court personally. But when it affects you personally, then the High Court is the forum. So the majority leader, the Honorable Afenyo Markin, is clothed with that capacity to pursue the matter under the 1992 Constitution, Article 2, Clause 1 of 130. So clearly for me, you know, Alfred, when you look at all of this, it's a clear mandate of the majority in Parliament continually exercising their right and franchise. I don't think that the minority in Parliament, which is the NDC, have earned that right from the bigger constituents of the Ghanaian people to be the majority. I don't see that. Because you see, Alfred, people have gone for elections. They have been voted into office to represent the interests of their constituents. Clearly, within the space we find ourselves, a few more days to a democratic election, which is to be held, for people to make a decision on who represents them again in Parliament and who leads this country for going. I think that there was no rush, really, on the side of the Speaker to immediately pass a reasoning of ruling.
But would you have said same in the case of the Right Honorable Aaron Michael Quay in the Fomena constituency case? This same argument that you're making, that the people of Fomena also deserved representation, and as a result of that decision, that human right was also violated. Would that find reason in your argument? You
know, Alfred, let me quote a few more cases. You see, because
no, I just asked a specific
no, of course,
question.
I mean, absolutely. You know, when they were making a comparison of the ruling of the respected Right Honorable Michael Quay together with in terms of precedents, okay, because it was an issue of precedents, that because an issue of precedents had happened in 2020, it bears foundation for same precedents to be applied in 2024. I disagree and want to disassociate myself from any thinking that goes with the precedents that because Right Honorable Speaker Michael Quay had made a precedence of that nature, it should be applied in the 2024 application. But the Republic versus the Fast Track High Court.
Why would you want to do that? Because in law you cannot in law you cannot do away with precedents and make an argument, because you say you don't find convenience in the precedent, so you don't want to make reference to it. But actually, this decision was not taken in a vacuum.
Alfred, my statements are very clear that there was no need to give a precedence of Right Honorable Michael Quay's ruling vis-a-vis Speaker Bagbane's ruling of 2024.
Why is that?
Because the situations are very different.
How different?
Very, very different. I think that the situations are very different.
How different?
There was no application that was made by the political party that represents these people, that these people are no more members of Parliament. Rightly so, these people are seeking to be independent members in the 9th Parliament should they win the election.
But what law actually demands that a political party should write to the Speaker before Article 97 1G can kick in?
You know, Alfred, it's purely based on who wants to write that. Our political party has not taken a position to write any letter to Parliament to state that these 3 persons that are seeking to stand independent are no more members of our political party. Because there's really no reasoning whatsoever to even convince us that these persons that are standing for independence would be voted into office in the 9th Parliament, because they are seeking their independence in the future Parliament, not the Parliament of today.
But that's beside the point. But if hold on, Prof, I'll come to you. But you see, if 97.1, and have you read the 97.1G?
I have.
And I'll read it to you, that a member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member. The law does not in any way say that your party must necessarily write to the Speaker.
Seeks to remain in Parliament as an independent member. Have these persons stated that they seek to remain in Parliament as independent members? The question is no. That's true. They have not stated that they seek to remain in Parliament as independent members. You know that. These persons have not decided that they will not do business with the New Patriotic Party or not do business with the government of the day. So they have not thought that they want to. It's not in my right place to say that.
But I mean,
you understand?
Professor Makokwe was wrong.
That's not what I've said.
But that's what he did.
Do you understand what I'm saying?
Then your reasoning, your thoughts aren't flowing properly.
Then you're not understanding me.
Dr. Palgrave, you are making an argument based on the references you have made.
Article 97, 1G. Let me state it. It says if he leaves the party of which he was a member at the time of his election to Parliament to join another party. Has that happened? No. Or seeks to remain in Parliament as an independent member. Has that happened? No. So very clearly. And it says that if he was elected a member of Parliament as an independent candidate or joins another political party. So for me, you see,
so which law did Professor Michael Quay reference in declaring the Fomena seat vacant?
Alfred,
which law did Professor Michael Quay reference in declaring the Fomena seat vacant?
I do not recall that.
It's Article 97, 1G and H.
Which is why we have had to go to the Supreme Court for an interpretation. Clearly. Because you see, if you look at Parliament, Parliament is not the supremacy of the 1992 Constitution. Yes,
but
the Supreme Court brings interpretation.
Which organ of government is...
The Supreme Court brings interpretation of every single thing that is stated in the 1992 Constitution. And I have case in reference to that, if you may. The Republic versus the Fast Track High Court, ex parte Commission on Human Rights and Administrative Justice, interested party, Honorable Richard Anani in 2007 said that we need to remind ourselves that there is no parliamentary supremacy under our Constitution,